How's it going, everybody? In this video, I want to talk about how New York is joining California and is planning to use the Texas abortion law to go after gun manufacturers and dealers who sell and make so-called assault weapons and ghost guns. So let's talk about this. But real quick before we jump into this video, if you think that liberal states like California and New York need to stop infringing on our Second Amendment rights, go ahead and hit that like button and subscribe. Also, I want to let you know that this video is sponsored by 80% Arms. 80% Arms actually has 80% lowers that you can purchase from them and build out. It's an amazing product, but laws like this that the state of California is going to try to put in place, and New York as well, target these products, target these items, and try to infringe on your Second Amendment rights by getting rid of them. So go ahead and show 80% Arms some support. Go check out their website, and thank you 80% Arms for sponsoring this video. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, this morning, New York Attorney General Letitia James was on The View of all places and was asked about recent comments made by California Governor Gavin Newsom. If you're not aware, Gavin Newsom came out this weekend and said that he has directed his staff to come up with a bill that allows gun manufacturers to be sued in a way that mimics Texas's abortion law. He said this bill would create a right of action allowing private citizens to seek injunctive relief and statutory damages of at least $10,000 per violation, plus costs and attorney's fees, against anyone, and that means anyone, who manufactures, distributes, or sells a so-called assault weapon or ghost gun kit, or even parts in the state of California. When asked if she would direct the state of New York to do the same, her answer was yes, she would do the same. She stated that New York will follow the lead of California in instituting these types of laws. She stated that gun manufacturers are the only industry that are protected from liability and that needs to stop. Now in this video, I want to shine some light on the actual laws and cases at play here, and also I want to clarify some points of confusion that have been circulating about what an SB 8-like gun law could actually do in a state like California or New York. Now first, what is SB 8, also known as the Texas abortion law, and why is it being used in the context of gun rights? SB 8 is a law passed in Texas that prohibits an abortion if a fetal heartbeat is present, which is at about 6 weeks is when that can be. This law is different from other laws because it is not enforced by the state of Texas or any of its executives, but rather it allows any individual to sue other individuals who perform or knowingly aid and abet an abortion. This includes individuals like medical providers, family members, friends, and really anyone who is in relation or helps, aids, and abets in an abortion. In these SB 8 lawsuits, an individual can seek an injunction against the performance of an abortion and also seek a minimum of $10,000 in damages against any violators. Essentially, the law's goal is to have a huge chilling effect on the performance of abortions because you could have thousands of people file lawsuits against you for just one specific incident. SB 8 went into effect on September 1st of this year, but prior to that, those opposing the law filed a pre-enforcement challenge in federal court. Now here's where things become relevant for the Second Amendment context and what California and New York are planning to do. Pre-enforcement challenges seek to stop the enforcement of a law before it takes effect and before people actually suffer a harm. However, SB 8 was designed in a way that shields Texas and its executive officials from pre-enforcement lawsuits, since the statute allows only individuals to bring lawsuits, not the state or its officials. Typically, when a law is enforced by the state, a plaintiff will seek an injunction against the state and its attorney general to stop them from using that law. But with SB 8 in this scheme, you can't get this umbrella injunction against the state or the attorney general since they aren't the ones enforcing it. Instead, the ones enforcing it are just random individuals who decide to sue you. This Texas abortion law recently found its way up to the Supreme Court for review. On review, the Supreme Court was only considering whether those challenging the law could seek pre-enforcement injunctions against the state, the attorney general, other state officials, and also Texas judges and clerks who assist in hearing these cases. The Supreme Court found that under prior precedent, established in a case called Ex parte Young, that the attorney general, the judges, and clerks have sovereign immunity / essentially protections on this issue since under SB 8, these individuals play no role in enforcing the law. So that's the backdrop of what SB 8 actually created. What California and New York are now planning to do is create a bill that will allow private individuals to sue anyone who aids and abets the manufacture or distribution of so-called assault weapons, ghost gun kits, or parts in their states. Now, those on the left have been after a way to sue gun makers and gun stores and distributors and all these people for a very long time. However, there is a federal law that prevents these types of actions. The Protection of Lawful Commerce in Arms Act, or the PLCAA, is a U.S. law that protects firearms manufacturers and dealers from being held liable when crimes have been committed with their products. One important thing to keep in mind, however, is that these companies and dealers can still be held liable for damages resulting from defective products, breach of contract, or their own criminal misconduct. But one of the caveats with the PLCAA is that it is an affirmative defense. A defense you can raise in a lawsuit to get the case dismissed, but the PLCAA at large may not be able to stop these lawsuits from even being filed. This could result in someone suing a gun maker or a gun store under this new California bill or law, and then having it dismissed on the grounds that the PLCAA protects that individual, protects that gun store, gun manufacturer, distributor, whoever, but then someone else could sue that same maker for that same issue, and then they would have to raise these defense of PLCAA protections all over again. That case gets dismissed, but then someone else, another individual, decides to sue them as well, and it goes on and on. So the goal with this bill and these types of lawsuits is not necessarily to win a case against these gun manufacturers or gun stores, but instead it is to make it so burdensome on them to actually operate in these states to where they decide that they just don't want to deal with it anymore and they just don't operate in the states. Now, I've also been hearing some say, well, California already has an assault weapons ban and a ghost gun ban, and that these types of laws won't do anything at all. To that, I would say that's half true, but also not true. California does have a ban on so-called assault weapons, as defined in Penal Code Section 30510 and 30515. I would expect, though, that in Newsom's comments, he was not referring to the legal definition of a so-called assault weapon in California. I would expect in his mind when he made those comments, he was referring to AR-15s in general as AR-15 style rifles, generally as assault weapons. So it would be a failure on our part to not take a bill like this serious because we already have a so-called assault weapons ban in the state of California. What could happen is that a definition of assault weapon, a new definition of assault weapon, could be included in this bill, and it could encompass all semi-automatic centerfire AR-15s. That's just a thought I have. But I think we need to still take this serious and just not brush this off as, well, we already have an assault weapons ban in the state of California. Also, many are forgetting that in his press release, he said the bill would target parts as well. Under Section 30515 of California's Penal Code, features like a collapsible stock, flash hider, pistol grip, forward pistol grip are all parts that can make a rifle a so-called assault weapon in the state of California. If through this bill, they say anyone selling or making these assault weapons parts can be sued, what happens then? That's a lot broader of a law than we have right now and should bring a lot of concern to people because he said that they were going to target parts. And also I've been hearing some people say, well, California already has a ghost gun ban. Currently, you actually can purchase 80% lowers in the state. There are restrictions and guidelines you have to meet with the state to build them, but it's not illegal for someone to manufacture 80% lowers here in the state or for a store to sell an 80%er to someone who actually wants to purchase one. Some of these laws are going to change soon where you can only purchase a firearms precursor part from a precursor part vendor who has a license from the state. And this would include pretty much just any gun store. But you could purchase them still from a gun store, but that you would just have to purchase them specifically from that gun store who has a license to sell them. But one thing this bill could do is make that process void, since a store who is a licensed precursor part vendor will decide not to sell 80% lowers, since they can be sued by anyone and anyone if they actually sell one of these items. If they sell an 80% lower, a polymer 80, or if they decide to sell maybe even any parts that could actually be used to build that out. So with this issue, let's not forget that these states have attorneys and legislators who have made their careers on coming up with gun control laws. They will likely come up with a way to make this work with the current gun laws and gun control laws that they have in place. However, that being said, any strategy they come up with will likely be a violation of Second Amendment rights, and I can say that pretty much with 100% confidence. And my expectation is that when they are challenged on this constitutional basis, they should be struck down by any of these courts. So hopefully that added some clarity on this whole issue. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting these videos, directly impacting this channel, and helping this channel and videos to reach more people than I could have ever thought. So thank you so much for all of your support. If you don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm. And also, if you're a new subscriber or a long-time lurker and you just subscribed, go ahead and comment down below that you're a new subscriber, and I'll make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will maintain by armed scholars.